Daniel.
Okay.
Taheem Ellis.
Okay.
Santos Escato.
Okay.
Normal Henderson.
Okay.
Vanessa Hernandez.
Okay.
Antoine Jennings.
Okay.
The next page, Nazir Ningson. Right up under Muri.
Okay.
And the name up under that, Pena, P-E-N-A.
Uh-huh.
Okay. Richardson, Ben Richardson.
Can I ask you one question? Did you say a Newsom?
No, Ninson, N-I-S-O-N, right up under Muri, M-U-R-R-Y.
Okay.
Yeah, Muri's still there. It's
Okay.
still up there, okay? And then
Okay.
Pena, P-E-N-A. Hold on one second, Judge.
Okay.
Richardson, you got Ben Richardson.
Okay.
Jasmine Standard.
Okay.
And Kamisha Wiley.
Okay.
Okay, that's everybody.
All right, you just made my day.
You're silly. Okay, sir, hold on one moment.
Okay.
You ready over there, Deputy Robinson?
Oh, Deputy Knox, who's the individual that we're gonna need for Ms. Bermudez?
Actually, we're not gonna need anybody. All the Hispanics that are here, they all speak English. The ones that didn't bonded out.
Okay. Ms. Bermudez, you can go.
Thank you, sir. Have a good day.
One moment, Judge Gardner.
Okay.
Judge Gardner, when you're ready, sir.
Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I am not here to conduct a trial of your case or to take a plea in your case. I am here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you if your case goes to trial. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you, If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail, and they may be cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office. The sheriff's office will hold the cash and return it at the end of the case. If you use a commercial bonding company, someone would have to pay a fee to the company for their service. The fee will not be returned. I don't know what fee will be charged, but it's usually based upon a percentage of the bond. Finally, if you use property to post bond, the property will need to have a net equity in an amount equal to 3 times the total amount of the bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. So now I need everyone to raise your right hand. Do you swear or affirm any statements you make during this proceeding will be the truth, the whole truth, so help you God? Okay, I'm ready, Deputy Knox, whenever you are. You can lower your hand. Uh-oh. Okay. I'm sorry, would you say that again, ma'am?
I said, good morning. My name is Wildalis Ches Mendez.
Good morning. Ma'am, you've been charged with 1 count of violating Georgia Controlled Substance Act. I'm setting a bond at $15,000. Do you believe you can post that bond?
No, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. This is my first offense.
I understand, but these are some serious charges.
Yes, sir. What would be the steps from here if I can't pay $15,000 in bond?
Okay. All right, first I'm going to find that you do qualify, so I'm going to appoint a lawyer to represent you. What I would encourage you to do is to call the bonding companies. The sheriff's office will give you a list of companies that are authorized to write bonds in this county. I will contact every one of them, tell them the charges that you have against you and the bond amount. Some bonding companies will put you on a payment plan. Some will work with you. Their business is getting people out of jail. It's not denying people from getting out of jail. So you're going to have to take those steps, okay?
Yes, sir.
I'm setting a preliminary hearing date for March 22nd at 8:30 in the morning. That's going to be, it's going to say courtroom 201, but it's going to be a Zoom hearing. Do you have any questions of me, ma'am, about your charges?
No, sir, I'll ask the sheriff for a list of the bail bonding so I can start the process.
Okay. If you don't have any other questions, you're free to go back.
Thank you.
You're welcome.
Hello, sir. My name is Janessa Bongora.
You've been charged with one count of cruelty to children in the first degree. I'm setting the bond at $5,000. You believe you can post that bond?
Not at the moment.
Okay. I'm going to tell you the same thing I told the other young lady. Contact the different bonding companies. Again, they'll work with you to try to get you out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. I'm setting a preliminary hearing date for March 22nd at 8:30 in the morning. I also would encourage you to, as soon as you can, to speak to your lawyer about these charges. This is something, it's a warrant. So this was sought by an officer for which another judge signed. So I don't have any say so in the matter. But the bond amount is one that I feel is the right amount for the charges. But, you know, I do believe that there's something that could happen in your case.
Okay.
Okay. Do you have any questions of me, ma'am?
No, sir. Thank you.
You're free to go back.
Good morning, Your Honor.
Good morning. Tell me your name, ma'am.
Christina Geddes.
Okay. Ms. Geddes, you've been charged with one count of simple assault and one count of simple battery. I've set the bond at both of these offenses at $2,500 for a total bond of $5,000. Do you believe you can post that bond?
Not in total.
Okay. Well, I would again encourage you to contact the bonding companies and tell them your charge so that I'm sure that they'll work with you. I've also put stay away provisions on your bond at this moment. To stay away from Caleb Geddes and Alice Washington. This is something that can be changed. So it's not something that has to be permanent, but we set stay away provisions on cases like this because we don't want whatever led to your being brought here before me to get started up again tonight or tomorrow morning. So I hope you understand that. Would you like for me to see if you qualify for the appointment of a lawyer? Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date for March 23rd at 8:30 in the morning, but that'll be a Zoom hearing like we're having here today. but once you bond out, that hearing date will be waived. Do you have any questions of me, ma'am?
Just one question. Since there is a stay, people, Caleb get or both children live in my home. And I was told that I cannot exit them out of the home. So how I don't want to I want to be in compliance with what your order is.
Right.
What do you suggest, or are there any suggestions?
Well, I'm going to ask you to repeat what you were saying because the Wi-Fi connection was kind of bad.
Oh, I'm sorry. I apologize.
Would you repeat it, please?
Because the stay away order, Caleb Geddes and Elise Washington are my biological children who live in the home with me. And I was told by officers that I could not move them out of the house without doing a eviction. Are there any suggestions, because I want to be in compliance with what you have ordered?
Yes, the process is called dispossessory, but it is a process where you file paperwork with the court saying that you want this person to leave. Now, it gets kind of complicated, and I'll try to make it as simple as possible, but there has to be sort of a landlord-tenant relationship. So if you have a child that's an adult and that child is living with you, you can't just kick the child out. You got to offer the child the opportunity to, in 30 days or 60 days or whatever, you have to leave. And then at the end of that process, if they still choose to stay, then you can come and seek to have them evicted. But the basic state of the law is that you don't want to have just people, getting kicked out. You and I enter into an agreement where I'm going to live at your house and you get mad at me a week later and you try to kick me out. That's unfair to me. But because of this whole process, with there being a stay away provision, currently it's going to complicate it even more. So it's just going to be something that you're going to have to speak to your lawyer about the best steps. But that's the overview is what I just gave you.
How long is the stay away order in place, Your Honor? That's my last question.
The short part is that it could be something that gets taken away this week. So for example, if Caleb Geddes and Alice Washington say, hey, we're not afraid of her. We don't care that what happened. They can contact the solicitor's office and say, hey, there's a stay away provision. We want that to change. So they can change it. Does that make sense to you?
Even though one is a minor?
Again, that complicates it. I mean, the unfortunate thing for me is that I have to make these decisions based upon this. I may not have made the certain decisions that the officer made, but I'm not here to second guess the officer at this point. And so that can happen with the solicitor's office or your lawyer getting involved, but those are the other people that can make that determination. And again, the reason that they want to do it that way, or the reason it's done that way, is because that secondary process, there are both sides involved. Right now, it's just you and I. So it's just a one-sided situation. So you can tell me whatever you tell me, and it could be the truth or it could not be the truth. So we need there to be a situation where there's at least two sides. Okay?
I understand.
Okay, any other questions?
No, sir. Thank you, Your Honor.
You're welcome. You're free to go back, man.
Have a blessed day.
You too. Are you
Oh,
Miss Gibson?
yes, sir.
You've been charged with one count of forgery in the first degree. I've set the bond at $10,000. Do you believe you can pay that bond, man?
Yes, if I can get in touch with my parents, they'll probably put property up on me.
Okay. Um, I've also set a preliminary hearing date for March 22nd at 8:30 in the morning. That'll be over a Zoom hearing like we're having here today. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, so I'm going to appoint a lawyer to represent you. Do you have any questions of me, ma'am?
No, sir.
Okay, you're free to go back.
Thank you.
You're welcome.
Hello,
Hi, tell me your name, ma'am.
Sky Stephen.
Okay. Ma'am, you've been charged with a number of offenses. The red light violation, the bond is going to be set at $500 for that. Improper lane change, the bond is going to be set at $500. The driving under the influence charge, the bond is going to be set at $5,000. The open container violation, the bond is going to be set at $500. The no insurance, the bond is going to be set at $1,000. The driving on a expired or invalid tag, the bond is going to be set at $500. Possession of marijuana less than an ounce, the bond is set at $1,500. And I'm setting the bond at $5,000 for the appeals. So that's going to be a total bond. Let's see, 13, 14. If my math is correct, $14,500. Do you believe you can post that bond, man?
No, sir. Can I interject for a second?
Yes.
Last night when I was pulled over by the police, they did acknowledge me of the wrong lane change and also of the tags, which me and my grandmother get reminded that all the time. We both got new cars last year off of Honda South and Morrow. They say due to COVID, our tags has been at a halt for the longest. I load them up every week. And I told them the next time I get pulled over because of that, I will have to take further action because that is not fair to me or my grandmother, you know. And I did have also passengers in the car with the open bottle thing or
Right.
whatnot. Once I asked them, once I started telling them about my I was going to show them in my glove compartment. The last time I went to Honda South, they had filled out the different forms with the police. They filled out the form saying that even though I don't have my tag, that is registered and the tags can be found under the police. So after I said that, he said he smelled wine or alcohol in my breath, which was an open can of like Old English or some beers. My uncles, they were in the car as well. So not to be like, oh, well, it was me, because it's, of course, it's many things I've done wrong. But the tags and all that, that's been already talked about before.
Okay.
With through my mother and everything, because she bought me and my grandmother's cars last year, and ever since we've been on Honda South behind about it because we know how strict the laws are, and I wouldn't want that problem being that I'm from California and I have a California driver's license and everything.
Right. So are you asking me a question about it, or you just wanted to tell me your circumstances?
I'm telling you my circumstances, but also the truth of what happened last night and the truth of my whole situation with the car and the tags and the vehicle not being registered, because it very much so is. He never gave me the chance to get out of my glove compartment the different files and everything that the Honda South did like 2 weeks ago, because they're taking their time with the tags and the license. I don't know why it's taking so long.
Well, I would suggest that you may want to speak to a lawyer about whether you can take action against Honda South.
Right,
The other stuff, as the operator of the vehicle, you are responsible for open containers, and it could be somebody sitting, in the back drinking a beer. You're responsible for the open container as the operator of the vehicle. And the appeals because they basically say that you made allegations related to taking the Xanax and drinking wine and that kind of deal. So I don't know I'm not, like I said, we're not here to try the case. I'm not here to say the truth or the non-truth of any of this stuff. If you want, I can see if you qualify for the appointment of a lawyer, because it seems like you're going to need a lawyer to deal with these charges. So do you want me to see if you qualify?
yes, sir, for the extra charges regarding the cars and everything found in the car and everything, yes, sir.
I'm going to find that you qualify. So I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for March 22nd at 8:30 in the morning. And I would encourage you to speak to your lawyer about everything that you just told me.
Yes, sir. I did let Honda South know that the next time, which is now the worst case scenario, I'm here now, 22 years old in jail. So thank you so much. So I do want to clarify, those big words you're saying. So March 22nd, so will I be able to get out soon? Because all of this is very startling to me.
Yeah. So what happens is when I'm done with this hearing with everybody, I prepare the bond orders and the paperwork and I send it back over to the jail, and then they get to work on it. And then when you make the arrangements to bond yourself out, the paperwork should be done by then. And then you can bond out, most likely later today.
Okay, thank you.
Okay, any other questions, ma'am?
Nothing, sir. Thank you.
Okay.
I appreciate it. Good morning,
Good morning. Tell me your name.
Dejanay Murray.
Okay. Ma'am, you've been charged with 1 count of criminal trespass and 1 count of obstructing an officer. I've set the bond for the criminal trespass at $5,000, and I've set the bond for the obstructing an officer at $2,500 for a total bond of $7,500. Do you believe you can post that bond, ma'am? Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
I'm sorry, the Wi-Fi connection is bad today. Could you repeat that?
Would it be a way that I can see if I qualify for a signature bond?
At this point, we're not doing signature bonds.
Okay.
So the bond, you're gonna have to post this bond. But as I've told other people, I would encourage you to contact the different bonding companies and tell them to charge and see what they're willing to do, because some of them will put you on a payment plan.
Okay.
Okay. You do qualify, ma'am. So I'm going to appoint a lawyer to represent you.
All right.
As I said before, you got a preliminary hearing date set for March 23rd, but that date is going to be waived automatically once you bond out.
All right.
Any questions?
No, thank you.
Okay, you're free to go back.
Good morning,
Good morning. Tell me your name, ma'am.
Chantrella Johnson.
Ma'am, you've been charged with 1 count of simple battery and 1 count of cruelty to children in the 3rd degree. I've set the bond at $5,000 for the simple battery and $2,500 for the cruelty to children in the 3rd degree. These are both misdemeanors. So we're gonna have a preliminary hearing date set for March 23rd, but that date will be waived upon bonding out. I've also put a stay away provision to, at this time, to stay away from Michaela Mumford.
Yes. What's the total bond amount, sir?
I'm sorry, 7,500 is the total amount.
Okay,
Do you believe you can pay?
yes.
Okay. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
Yes, can you see if I can qualify for the lawyer, please?
You do qualify, ma'am, so I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, I don't, thank you.
Okay, feel free to go back.
Okay.
Good morning. My name is Ashley Washington.
I'm sorry, could you say that again?
My name is Ashley Washington.
Okay. Ms. Washington, you were charged with one count of criminal damage to property in the second degree. It's being charged as a felony. You're gonna have a preliminary hearing date that's gonna be set for March 22nd at 8:30 in the morning. I'm setting a bond for that at $5,000. Do you believe you can post a bond?
No, sir.
I'm also putting a stay away provision on your bond right now to stay away from John Henry Collins,
Yes,
but
sir.
that can be changed at some time in the future. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am, so I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I do have a question. When the officers were at the house, doing the investigation or whatnot, they didn't take pictures of any of my body parts, because I was attacked, and that's the reason why I did what I did. I was attacked by him, and it wasn't the first time. So how would I go about doing that?
Well, I've appointed you a lawyer. You should definitely speak to the lawyer about that and about the particular circumstances of your case, because the lawyer is the person that can advocate on your behalf with the prosecutor, and maybe get a favorable outcome in this case.
Okay, thank you so much.
You're welcome.
Have a good one.
You too.
Judge Gardner?
Yes.
The charge, excuse me, I'm sorry, sir. Ms. Andrews and Mr. Billings are gonna have to be done last.
Okay.
They're in a separate location. So
Okay.
you can start with the other males at this time, if you're ready to.
Yes, I am.
Okay, sir. Deputy Robinson, when you're ready, sir.
Okay, Judge.
Good morning.
Good morning, Judge. Willie Alford.
Okay.
Good morning, sir.
Good morning, Mr. Alford. You've been charged with a number of offenses. Violation of Georgia Controlled Substance Act, possession of drug-related objects, theft by receiving stolen property, possession of a weapon during the commission of a crime, another violation of Georgia Controlled Substance Act charge, possession of a firearm by a convicted felon, and trafficking in ecstasy. The bond, there are going to be bonds set on 2 of the offenses, but bonds are not going to be set on the remaining offenses. So you're going to have a $1,500 bond for the possession of drug-related objects and a $2,000 bond for theft by receiving stolen property. But for the other felony drug-related offenses, bond is not going to be set at this time. I'm going to set a preliminary hearing date for March 22nd, and I'm going to set a bond hearing date for March 26th. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
You can see if I qualify, sir.
Okay. You're going to be on the outer edge. But I'm going to find that you qualify, Mr. Alford, and I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Thank you.
Dr. Allen?
Hey, sir, how you doing?
Good morning.
Good morning.
Mr. Allen?
Yep.
Okay, Mr. Allen, you've been charged with a number of offenses also. But your criminal history was not as bad as before, but you're gonna have bonds set, but they're gonna be higher. So possession of a weapon during the commission of a crime, bond is gonna be set at $10,000 for that. Use of a communication facility, basically using a phone to facilitate drug sales, bond is gonna be set at $5,000 for that. Use or possession of drug-related objects, the bond is going to be set at $1,500. Improper lane change, bond is going to be set at $500. You have 2 violation of Georgia Controlled Substance Act charges. I'm setting the bond at $10,000 a piece for those. And possession of THC oil, I'm setting the bond at $5,000. So you're going to have a total bond of $42,000. Do you believe you can post that bond?
Yeah, I believe so. Yes.
Okay. We're gonna have a preliminary hearing date set for March 22nd at 8:30 in the morning. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
Can you see if I could qualify? And how much would a lawyer cost? Do you know?
Lawyers charge varying fees. So you would have to call the particular lawyer, and they'll tell you what they'll charge you for these offenses. But you do qualify for the appointment of a lawyer. So if you want me to appoint a lawyer, I will appoint a lawyer.
All right, can you do that, sir?
You will. And if you choose to hire a lawyer later, you can.
All right, thank you.
You're welcome. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Okay, passport.
Good afternoon, sir.
Good afternoon. You've been charged with 1 count of open container violation and 1 count of possession of marijuana less than an ounce. The bond for the open container is going to be $500. The bond for the possession of marijuana less than an ounce, it's going to be $1,500 for a total bond of $2,000. Do you believe you can post that bond?
Yes, sir.
Setting a preliminary hearing date for March 23rd, but that date is going to be waived upon your bonding out. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
I'm sorry.
I don't need a lawyer, sir.
Okay. Well, if you don't have any questions, you're free to go back.
Thank you.
You're welcome.
Vincent Brooke.
Good morning.
Good morning, Mr. Brooks. You've been charged with 1 count of trafficking in marijuana. At this point, I can't set a bond for this charge because it appears as though you're still on probation. That is what is showing on your criminal history.
I'm not on probation, sir.
Okay. because it's showing on your criminal history, I have to deny bond for the felony offense. Now, what I can do is I can appoint a lawyer to represent you if you qualify.
Yes.
Okay. You do qualify, Mr. Brooks. First thing I would tell the lawyer is that the reason you're being denied bond is because the judge said that it was showing that you were on probation. And if that's not true, then you will qualify for a bond. Okay?
When will I be able to speak to this lawyer?
The paperwork goes over to the lawyer today. So they'll know that you they have been appointed to represent you. I can't tell you how long it'll take. It'll probably take a day or two for somebody to contact you, but the paperwork will be there this afternoon. So tomorrow, at a minimum, you should be able to contact someone and say, look, I've been denied bond because the judge said that I was on probation, but I'm not on probation. Okay?
Yes, sir.
I'm setting a preliminary hearing date for March 24th. I'm also gonna preset a bond hearing date for March 26th. But as I said before, if that situation is not true, that's something that the lawyer can work with the district attorney's office to get changed.
I do have a question. If they can't prove that I'm not on probation anymore, then when will I be able to bond out? If they can't prove I'm not on probation anymore.
Okay, I think what you're saying is like, if you can show that you're on probation, when can you get out?
No. If they can't see that I'm not on probation anymore, if they can't contact whoever let me out, then when will I be able to bond out again?
Okay, if they can't, because it's showing up on your criminal history.
Okay.
So if that's a mistake, then that's something that you need to show is a mistake.
But what if it's not?
If you're on probation, then you can ask for a bond hearing and have it set. But this is something that what happened was they put this in place so that if you're on probation and you get arrested, you don't just bond out and then people are trying to find you. So that's the reason that it's there. So you can get a bond hearing, or you can get your lawyer to contact the DA's office and they may agree to something. And if there's a consent agreement between the lawyer and the prosecutor, judge will sign the order and you'll get out. But I can't tell you like, that's gonna happen Thursday, it's gonna happen Monday, it's gonna happen on this date. I've set these dates so that at a minimum, if everything falls through the cracks, you're gonna appear on a calendar. And you're not just gonna be sitting there. Okay?
All right.
Any other questions?
No, sir.
Okay, you're free to go back.
Okay, Your Honor, the next person gonna be Tommy Cooper.
Okay.
How you doing?
Mr. Cooper,
Yes, sir.
you're here under a little bit different circumstance than everyone else. You're alleged to be a fugitive from justice, and what that means is that there's a probation warrant out of Tuscaloosa, Alabama, for a burglary charge. And so when this happens, they contact the jurisdiction, and if they say, we're gonna come get them, or we wanna prosecute, or we wanna deal with this, then you go through this process. And so I gotta explain something to you, and then I'm gonna ask you some questions, and you make a decision about what you wanna do.
Yes, sir.
So you don't have charges pending here in Clayton County.
Yes, sir.
But you've been brought here because you've been alleged to be a fugitive out of the state of Alabama, and for the burglary charge. So are you in fact Tommy Cooper?
Yes, sir.
Okay. Do you already have a lawyer representing you in this matter?
In Alabama, yes, sir.
Okay. have you had an opportunity to speak to the lawyer about whether the lawyer is going to be able to clear this up in Alabama?
No, sir, I haven't talked to nobody.
Okay, so you have the right to demand a hearing to determine whether the warrant is valid. And at that hearing, the only thing that'll be determined is whether you are Tommy Cooper, whether there is a warrant out for your arrest. And then you'll be asked, what do you want to do? And if at that hearing, it's determined that you are Tommy Cooper and the warrant is valid, then there will be a warrant issued, or the governor will sign an extradition warrant for you to get sent back to Alabama.
Yes, sir.
If you believe that there is a warrant for your arrest and you believe that you are Tommy Cooper, you can waive that process right now.
Yes, sir.
And that'll put a clock on Alabama to come and get you.
Yes, sir.
So the sheriff's office, if you waive your extradition hearing, the sheriff's office will contact Alabama and say, hey, he's ready to come for you guys to come get him.
Yes, sir.
And generally they'll have 30 days to come get you. Under some circumstances, it may extend out to 60 days. But generally after that 30-day period, if they haven't come and gotten you, the sheriff's office here will contact them and say, hey, what's going on? So that speeds up the process by waiving the extradition hearing today.
Yes, sir.
But if you believe that you can get it worked out in Alabama, sometimes people say, look, I want a hearing because I believe I'll get it worked out here or get it worked out there, and I'll just be able to leave here. Because sometimes Alabama will say either we will, instead of coming and getting the person, we'll set a bond, and that person can bond out and leave Clayton County and go to Alabama voluntarily. Or they'll work the circumstances out in Alabama, and then Alabama will contact Clayton County and say, we don't want to come get them anymore. And then Clayton County will let you out. So I hope I haven't confused you about this.
A little bit, but I kind of get it.
Okay, well, ask me whatever questions that you want to ask.
You answered them. You said if I sign the waiver, it'll speed up the process.
Yes.
And then you said if I don't sign the waiver, I could go to court down here and Alabama could let me out with a bond down here.
If that's what you're trying to do, because sometimes people will say, look, I know that I can work this thing out. It's a probation violation for burglary in Alabama. So they may not want to make any kind of concessions. They may say, we want to bring him down and deal with it. In that circumstance, it's probably better for you to waive the hearing and go straight there and deal with it. If it's a, shoplifting or something where they're like, yeah, we don't want to deal with this guy, then you may say, well, hey, I don't want to go through that whole waiver process because I think I can deal with it down there. So say it's the shoplifting scenario, and they say, all we want is for him to pay $500 fine that he didn't pay, and we'll let him go. So you pay the fine, and they contact sheriff's office here and say, we don't want him anymore. But if it's something where you're looking at 20 years in Alabama, the likelihood of them allowing you to leave here on your own is low.
Yeah.
So you have a lawyer, you understand the circumstances a lot more than I do. All I know is that there's a probation violation warrant for burglary, and they said they're going to come and get you. So
I'd rather waive it to go and let them come get me quick as possible.
Okay. Well, I have paperwork here that I've signed, the waiver forms, and when I'm done here, they're gonna I'm gonna send them back over, and then somebody from the fugitive squad there at the jail is gonna come bring the forms over for you to sign. Okay.
Judge, I already have the form, so I'm just gonna go ahead and let them sign it.
Okay.
And then I'll send them to you.
Okay. Now, you guys actually attached the forms. So I've already signed them.
Okay,
So whatever works for you.
yes, sir. Okay,
I mean, what works better for you? Because I'm I'm gonna be here.
okay, Your Honor, I'll just let them sign it, then I'll send them to you,
Okay.
okay?
All right. Thank you.
Yeah. All right. Judge, you should have Mr. Bolton next.
Okay.
I skipped him by mistake. Do you have his paperwork?
Yes, I do.
Okay.
Mr. Bolton, you've been charged with a number of drug-related offenses, and possession of a weapon during the commission of a crime and use or possession of drug-related objects. I've set a bond at $1,500 for the use or possession of drug-related objects, but I've denied the bond for possession of a weapon during the commission of a crime and the 4 drug-related object. I'm sorry, 4 violations of Georgia Controlled Substance Act. I'm setting a preliminary hearing date for March 24th for you at 8:30 in the morning. And I'm also setting a bond hearing date for March 26th. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
You can see if I qualify.
You do qualify, Mr. Bolton, so I'm going to appoint a lawyer to represent you. Do you have any questions of me?
If I bond out on that other charge, will I get out or will I?
You'll have to wait. You won't be able to get out because of these other charges. But I have appointed a lawyer to represent you. And the lawyer may be able to work with the district attorney's office and they may consent to a bond.
Okay.
Okay, any questions?
No.
Okay, you're free to go back.
Okay, Judge, you should have Jermaine Dorsey. He should be next.
Okay.
Okay.
Good morning.
Good morning. Mr. Dorsey, you've been charged with 1 count of criminal trespass, damage to property. I'm setting the bond at $5,000 for that, and I'm putting a stay away provision on the bond to stay away from Santricia Fanning.
Yes, sir.
Do you believe you can post this bond, sir?
Yes, sir.
Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
Can you see if I qualify, sir?
Sure. How much do you earn per month, Mr. Dorsey?
About 1,700.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir. Thank you.
You're welcome. You're free to go back.
Julius Evans.
Okay.
Good morning, sir.
Good morning, Mr. Evans. You've been charged with 1 count of driving on a suspended or revoked license. The bond is set automatically at $1,500 for that. Do you believe you can post that bond, sir?
Yes, sir.
Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
Well, you can see if I qualify.
You do qualify, Mr. Evans. I'm going to appoint a lawyer to represent you.
Yes, sir.
I'm going to set a preliminary hearing date for March 23rd at 8:30 in the morning, but that date is going to get waived upon your bonding out.
Yes, sir.
Do you have any questions of me?
No, sir, I don't.
Okay, you're free to go back.
Thank you.
You're welcome.
Okay, we got Deontay Godfrey.
Good morning, Your Honor.
Good morning, Mr. Godfrey. You've been charged with one count of improper lane change and two DUI charges, alcohol less safe and DUI refusal. The bond is going to be set at $500 for the improper lane change and 500 for the improper lane change and 5,000 for the DUI alcohol less safe for both of those, for a total bond of 10,500. Do you believe you can post that bond, sir?
Yes, sir.
You plan on representing yourself, hiring your own lawyer, or do you want me to see if you qualify for the appointment of a lawyer?
You can see if I qualify, sir.
I'm going to find that you qualify, Mr. Godfrey. I'm also going to set a preliminary hearing date for March 23rd at 8:30 in the morning, but that date is going to get waived upon your bonding out. Do you have any questions of me?
No, I do not.
Okay, you're free to go back.
Thank you.
Give me 1 second.
Yes, sir.
Okay, I'm ready.
All right, Your Honor, this is gonna be Roger Green.
Okay.
Good morning, Your Honor.
Good morning, Mr. Green. You've been charged with one count of driving a vehicle with no license. The bond is set at $1,000 for that. Do you believe you can post that bond, sir?
Yes, sir.
I'm also setting a preliminary hearing date for March 23rd at 8:30 in the morning, but that date is going to get on your bonding out. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
Can you see if I qualify, sir?
Sure. Mr. Green, so I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir, Your Honor.
Okay, you're free to go back.
All right, thank you.
You're welcome.
Gardner.
All right, next person gonna be David Hudson.
Okay.
Judge Gardner.
Yes, ma'am.
This is Mary. Can you call me before you go to the next person, please?
Sure. Give me 1 second.
Okay.
Deputy.
Yes, sir, Judge.
We have an attorney, Miss Luncheon. And I wasn't aware of that. Her client is Anthony Reed. Is it possible that you could bring him up?
Okay, okay, here he comes, Your Honor.
Okay. Good morning, Ms. Lunton, or good afternoon.
Good morning. Good afternoon, Your Honor.
Mr. Reed. Hi. I just found out that your attorney is here, or otherwise I would have taken you sooner. Ms. Luncheon, Mr. Reed has been charged with carrying a weapon or a long gun. Looks like at the airport, like there was a weapon in a bag.
That's correct, Your Honor.
And theft by receiving stolen property. The weapon was alleged to have been stolen out of city of Chambly. There's going to be a total bond set of $5,000, $3,000 on the carrying of weapon, and $2,000 on the theft by receiving stolen property. He's going to have a preliminary hearing date set for March 23rd, but that date is going to get waived upon him bonding out. And he's already taken advantage of his right to hire his own lawyer. Do you have any questions of me, Ms. Luncheon?
I do not, Your Honor.
Okay. Well, Mr. Reed, you're free to go back.
All right, thanks, John.
You're welcome. You're free to go. And I didn't know that you were.
It's not a problem, Judge. I was waiting my turn. So that's fine. Thank you, Judge. Next time I'll speak up a little sooner.
Okay.
Thank you. Thank you.
You're welcome. So we're back to Mr. Hudson.
Yes, sir, Your Honor.
Okay. Mr. Hudson, you've been charged with one count of theft by taking, being a motor vehicle. I've set a $20,000 bond on that. Do you believe you can post that bond? I've also put a stay away provision on your bond to, for the time being, to stay away from a Miss Ulisha Young Hudson. And that provision can be changed at a later date. But based upon the allegation, I'm putting that stay away provision on this bond. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. You do qualify, Mr. Hudson, so I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for March 24th at 8:30 in the morning. That'll be over a Zoom hearing like we're having here today. I'm also going to set a bond hearing date for March 26th. Do you have any questions of me, sir?
What if the whole thing was like a misunderstanding, Your Honor? And I'd spoken with my parents about it because like my father said I could use the vehicle, and my mom didn't know that my dad said I could use the vehicle. So I was trying to, like, we had tried to get the whole case like dismissed and thrown out because it was a whole misunderstanding, but Clayton County had picked up the case.
Okay. So I'm looking at a warrant that was actually prepared December 26th, 2018. Yes, sir.
Yeah, that's what this whole thing, that's the whole reason I'm in here, is for this warrant, because since we couldn't get it figured out, I just like, never cleared it up, basically.
Well, what you're gonna have to do is get your lawyer to contact the district attorney's office to see if they're gonna move forward with this case or not.
Okay.
Okay, because it's been pending for a long time, and that's more than enough time to try to get it worked out.
Yeah, sure.
Okay. So do you have any questions of me, Mr. Hudson?
No, sir.
Okay, you're free to go back.
Okay.
Okay, next on there's gonna be Johnny Langley.
Okay.
Good morning, Judge.
Good morning, Mr. Langley. You've been charged with 1 count of criminal trespass and 1 count of obstructing an officer. I've set the bond for both of these offenses. I'm sorry, the bond for the criminal trespass is set at $1,000, and the bond for the obstructing the officer is set at $1,500 for a total bond of $2,500. Do you believe you can post that bond, sir?
No, sir.
Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Langley. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for March 23rd, 8:30 in the morning, but that date is going to be waived upon your bonding out. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
What do you want? Can I talk to you?
I'm sorry, can you do what?
Can I holler at you? Can I talk to you?
Yes, you can ask me any questions that you want to ask, Mr. Langley.
The criminal trespassing, criminal trespassing charge. If I were paying to stay in this motel, how would it be criminal trespass?
In Georgia, criminal trespass can be accomplished in 2 ways. One is that you deprive someone of their property. I take the phone and I throw it down and break it. You can't use it anymore. That could be criminal trespass. Or you're asked to leave a place and you don't leave, or you're asked not to come back and you come back. That could be criminal trespass. In this situation, they're saying that you violated the criminal trespass statute by returning to this Falcon Drive address, room 243, after you were being basically told not to return, to leave and not to return. So that's the allegation.
Well, I was staying there with somebody on.
Which, and that may be a complete defense. And that's why we do this whole thing of finding people lawyers as quickly as possible. Get a lawyer that.
Yeah.
And do what lawyers do.
Okay, so and that's why I got thrown down, y'all. I ain't no squishing on no officer, and then they throw me down for that.
Okay.
All right.
All right, you're free to go back, Mr. Lincoln.
Okay, Judge, the next guy, we're gonna be DeAndre Johnson.
Okay. Good morning, Mr. Johnson. You've been charged with terroristic threats or acts, possession of marijuana less than an ounce, and obstructing or hindering a law enforcement officer. I'm setting the bond at $3,000 for the terroristic threats or acts, $1,500 for the possession of marijuana less than an ounce, and $1,500 for the hindering law enforcement officer. At this point, I'm gonna have to put a stay away provision on this bond as it relates to DeAndre Johnson, and it appears like this is your child.
That's my son. My son stay with me.
The problem that I'm having, Mr. Johnson, is the allegation that you threatened to kill yourself and your son.
Myself.
I'm just telling you, okay, because this is not the time to have the trial. I need you to understand what's going on in my mind, in my thinking,
Yes, sir.
so that you can tell your lawyer that, and your lawyer can advocate on your behalf. But it's a problem for me to have that as an allegation. And it could be something that was said offhand, off the cuff, who knows? All of that stuff can be worked out later. But try not to get yourself into this situation again, please, sir. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. How much will I have to pay right now? How much?
It's going to depend on the bonding company, but it may be $600. It may be something less. It may be something more.
All right.
The sheriff's department has a list of bonding companies that are authorized to write bonds, and some of them will put you on a payment plan. They'll work with you, okay? You do qualify for the appointment of a lawyer, so I'm going to appoint a lawyer to represent you.
Okay.
You're gonna have a preliminary hearing date set for March 23rd at 8:30 in the morning, but that date is gonna get waived upon your bonding out.
Yes, sir.
Do you have any questions of me, Mr. Johnson?
No, sir.
Okay, you're free to go back, sir.
Timothy Murray.
Okay, Mr. Murray, you've been charged with 3 counts of aggravated assault and 1 count of cruelty to children in the 3rd degree. Bond is going to be denied at this point on all of these offenses. I'm going to set a preliminary hearing date for March 24th at 8:30 in the morning. I'm going to also set a bond hearing date for March 26th. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you qualify, and I'm going to appoint a lawyer to represent you.
Thank you, Your Honor.
You're welcome. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Thank you.
Next guy, Your Honor, gonna be Tony Pomachi.
Okay.
Yeah, Tony Pomachan.
Pomachan, okay.
How you doing, Your Honor?
I'm doing well. Sir, you've been charged with 1 count of forgery in the 4th degree, 1 count of forgery in the 3rd degree, and 1 count of forgery in the 4th degree, or a 2nd count of forgery in the 4th degree. I'm going to deny the bond on the felony charge at this point.
Your Honor,
Yes, sir.
I think, I'm not for sure, but I think I made bonds on those charges already. I was in here like 2 weeks ago, and I would bond out from any time. I went to court. Without fingerprinting, and they actually brought me over there to get a bond from the judge, and because these charges came up to me late.
Okay, when you say late, what do you mean by that?
They had some extra charges coming when I was about to bond out from any time. And my lawyer actually saying that they got 4 other charges came in. They didn't even know. And then we had to wait for it, go to court. And she gave me a bond, and then I came back and got fingerprinted. I think that's what those charges are for, sir.
So the three different charges, one is from allegedly happened on November 12th.
Yeah, this. I was in here 2 weeks ago, Your Honor. That's why I didn't know I had no charges or none of that was in November. I posted bond 2 weeks ago.
Okay, let me finish.
Okay.
One for November 11th. I mean, November 12th, one for November 13th, and one for November 16th.
Those charges came from last week too. The one I came in, I was bonding out. Those charges were old too.
All of the warrants were obtained on January 12th.
Yes, sir.
Okay.
I was in here. See, when you say that it happened November, I was already locked up in December, and I was still here in January, sir.
So what I'll do is I'll look at this. The reason I was denying bond is because you have a long history.
I know, but I mean, I've been trying to do good, and like I said, Your Honor, don't get me wrong or nothing like that. I mean, I bonded out, I stayed because my mom got cancer, I got cancer. And what it is like I said, I'm too old for ridiculous stuff. And this is back then in my past. This is my past here.
So what I'll do is I'll take a look at it, because like I said before, you have a long history and you have similar charges.
I understand.
So I don't know if this is something that is getting just mixed up in the wash or whatever.
I hope not, I hope not.
So what I'll do is I'll check on that. And if this is something that bond has already been set, or that, like you said, you've already been before a judge.
Your Honor, I mean, in your past record, do you see that I am on bond? Or do you see it on file?
What I've seen recently, or what I saw recently, was that there was something out of Henry County that was a similar charge. That was before this was your most recent arrest, forgery in the 4th degree, I think.
Yeah, I mean, that's all these charges here. Your Honor, I mean, that's why, this is old charge case. I was bonded out. I have no idea, Your Honor, be honest with you. Like you say, this is old cases today. I don't even know that I wouldn't even do nothing. And I bonded, I mean, if they had a warrant out by then, why would they actually let me go?
Who's your lawyer?
Steve Smith, Vernon Smith,
Vernon Smith.
Yes, sir.
Okay.
He's the one who actually looked in the case about the other 4 charges that came out of nowhere. And because I had all the other charges, you know, I don't know, I mean, really be honest with you, Your Honor, I mean, I paid.
So what I'll do, like I said, I will look into this and it will be a decision made today. All right. If this has already been taken care of, then I'm going to go with whatever has been done by the previous judge. Okay.
Well, yeah, I mean, if you go to the previous judge, yeah, I understand that right there, because like I said, she's the one who gave me the bond, and I mean, it's just, and like I say, sir, I just don't know what to do, you know? I mean, I just bonded out 2 weeks ago.
Well, you have a lawyer, and like I said, like when you said you bonded out 2 weeks ago.
I think it was like on the 26th. On the 26th,
okay.
Sir.
Okay. So let me look into that. And then, like I said before, if this has already been taken care of, I'm going to go with what the previous judge did. Okay.
Thank you. Thank you. I mean,
okay. All right.
What say like this, if this is new cases, Judge, I'm just trying to ask, and I know you denied my bond right now, but the previous judge gave me the bond, would you reconsider? So, because like I say, I don't want to throw, because Yana, I just don't want it, because my family put that money on me and try to be good, try to be right. You know,
okay, let's try it this way. Hold on. Let's try it this way. I want you to repeat back to me what I said to you.
Okay. I'm trying to, you say you're going to try to reconsider what the last judge did for me, just to be out of, because if I make bond, am I right? Because like I said, I mean, that's what I'm trying to understand.
Okay. Now, don't cut me off.
No,
listen.
Yes, sir.
Practice, like, use your ears, not your mouth. Okay. What I hear you saying to me is that you have already bonded out on these charges, correct?
I'm not for sure, but I think it is. I'm not. That's what I'm saying, Your Honor. I don't know those charges. I never seen them before. I never seen those charges before.
So, all right, I'm going to read this to you so you can understand, okay? It says on November 12th, 2020, you went to Old Dixie Road and Forest Park and you presented a check and received money in the amount of $968. And it said that the check was fraudulent and Clayton County's public schools was the victim. The check was allegedly from Clayton County Public Schools to you, and you got $968. Okay, that's the first one. All right. The second one says on November 13th that you went to where is this?
This November 13th and November 2. Both of them in November, sir?
Yes, of 2020. And that you presented a check in the amount of $1,590, and you got paid that amount of money, and the check was, when they say purported, but the check was saying that Clayton County Schools was giving you that amount, and they said that the check was fraudulent. The last charge is on November 16th of 2020 that you presented a check in the amount of $1,450.
That sounds like 3 days apart.
Yes,
I'm sorry, yes, sir.
Days.
Yes, sir. Yes, sir.
Okay, so, all right. I feel like we're having a problem in communicating because I'm trying to give you information and you're trying to tell me you don't think it's right. So wait a minute. Your lawyer is the person that fights that. I'm advising you of what you're being charged with.
Thank you, sir.
So that you can let your lawyer know, hey,
I will.
That's what happened. So now, as I said before, and I don't want to sit here and have an hour-long conversation about it.
Yes, sir.
But you said you don't know if this has already been taken care of by the previous judge. That's what I'm going to look into. If it has already been taken care of by the previous judge and the previous judge has written you a bond, I'm going to honor what the previous judge did.
Thank you.
All right, we're on the same page.
Thank you, sir. What am you saying that you will honor me a bond? What the last person did?
If this is the exact same thing, yes, I'm not going to override that previous judge.
Thank you. And how would I know about this?
The paperwork will come over today, and the jail will let you know. Okay.
All right.
All right. You're welcome.
Thank you, Your Honor.
All right, you're free to go back.
Thank you.
Okay, Judge, last one, Mario Teasley.
Okay.
Good afternoon, Judge.
Good afternoon, Mr. Teasley. You've been charged, I think, yes. You've been charged with 3 counts of violation of Georgia Controlled Substance Act, 1 count of possession of a weapon during the commission of a crime, 1 count of use or possession of drug-related objects, and 1 count of possession of firearm by a convicted felon. I'm setting a bond in the use or possession of drug-related objects at $1,500, but I'm denying the bond in the other 5 offenses. I'm setting a preliminary hearing date for March 24th at 8:30 in the morning. And I'm also setting you a bond hearing date for March 26th at 8:30 in the morning. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
See if I qualify, but I have a question for you, Honor.
Yes, sir.
The first 3 charges, you said Georgia Controlled Substance Act.
Yes, 1 is possession of marijuana more than an ounce. That's felony. 1, possession of marijuana with intent to distribute. The other one is possession of a Schedule II narcotic, being oxycodone. And I denied the bond for the other person that was also in this situation because of this search warrant. So, well, and your criminal history is a little bit extensive.
I understand that, Your Honor, but I ain't gonna incriminate myself.
Yes, please don't. Please don't. You do qualify, so I'm going to appoint a lawyer to represent you. Do you have any other questions of me?
Really, like, due to my record, or is it because I'm on probation that I got denied the bond? That's what I really want to know, because
It's both, and the probation is something that, well, they both, you can have hearings, and so you can have bonds set. So it's not a situation where you're just never going to be able to qualify for a bond. But at this stage, based upon what I see in here in your criminal history, I just didn't want to set a bond.
I understand. I have a lawyer contact you if I can. Well, I'm gonna talk to my mom, see if they gonna, you know what I'm saying? But
okay.
But for the past time, looking at for me for the attorney for me, Your Honor.
Okay, so I did appoint.
Okay, cool.
And that lawyer will contact you. And if you plan on hiring a lawyer, you can hire a lawyer.
I understand.
Okay. Well, you're free to go back.
All right.
Okay, Judge Gardner?
Yes.
This is Mr. Billings, and then after him is gonna be Ms. Andrews.
Okay. Mr. Billings, you've been charged with a number of offenses, burglary, sexual battery, aggravated assault, terroristic threats, kidnapping, theft by taking. I can't set bond on any of the other offenses, but the battery, because it's a misdemeanor, I set bond at $5,000. I'm going to set a preliminary hearing date for March 24th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
He said, yes, sir.
Okay. I'm going to find that you qualify, Mr. Billings. I'm going to appoint a lawyer to represent you. And as I think I said before, you're going to have the preliminary hearing date of March 24th and a bond hearing date of March 26th. Any questions of me, sir?
He said, no, sir.
Okay.
Okay, hold on 1 second, Judge Gardner. I'm gonna get Ms. Andrews.
Okay.
Okay, Judge Gardner, this is Ms. Andrews.
Okay. Ms. Andrews, you've been charged with 1 count of criminal damage to property in the 2nd degree. I've set the bond at $10,000. Do you believe you can post that bond, ma'am? Did she say no?
She didn't answer yet.
Okay.
I probably can. She said yes, she probably can.
Okay. You've been charged with a felony, so I'm setting a bond. Setting a preliminary hearing date for March 22nd at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Can I represent myself?
Yes, if you want to, you can.
Okay.
Okay. Do you have any questions of me, ma'am?
Where is it for though? Can I get a discovery package?
Yes, at some point you will get to that point, but this is, if you use a doctor analogy, you're at the point of you're in the waiting room, you hadn't even signed in yet. So it's like you hadn't even signed in and you're asking the doctor what's wrong. So you're not at that process yet where you have the discovery packet, but it will come.
So that means I don't need a bond yet. I should be free to go.
That's not how it works.
That means you're still trying to get the evidence together.
Well, the allegation is that you took a big brick and threw it through a window or door at the Burger King and caused $1,800 worth of damage. So that's the allegation. And you should get pictures and witness statements, and they probably have surveillance videos. So all of that stuff is coming.
Yeah, because I was there and I was homeless. So I was like, should I just take the charge?
Okay. So are you sure you want to represent yourself?
Yeah.
Okay.
Go for it.
That's your right. So do you have any other questions, ma'am?
Yes, sir. No, sir.
No.
Okay, you're free to go back.
Okay.
Okay, Judge Garner, that should be everyone.
Yes. Thank you, Deputy Knox. You have a good day.
Thank you, sir. You too. See you tomorrow.
Okay.
All right.